Clerk will read the caption to House Bill 720. House Bill 720.
House Bill 720 by Representative Saints, the 180th, to be entitled an act to amend Article 1 of Chapter 10 of Title 17 of the Official Code of Georgia annotated relating to procedure for sentencing and imposition of punishment. This bill having referred to the Committee on Judiciary Non-Civil, that committee recommended that this bill do pass by committee substitute.
The chair recognizes Representative Sains to present the bill.
Thank you, Madam Speaker. House Bill 720 addresses the new environment our state's public safety network is in after the decision of Park v. State last year and ensuring compliance for our state assessed dangerous sexual predators. One of the major provisions of the bill allows for GPS tracking for twice adjudicated sexual predators who are much higher risk of being labeled a dangerous sexual predator. It also provides for great work Representative Mandy Ballinger has been working on in terms of the Offender Risk Review Board. It names them to clarify what they do, which is level our sexual offenders. And this will allow for clarity and also a more comprehensive report through making sure they have access to all departments' information on that sexual offender. It also clarifies that that a statutory rape defense, any individual under the age of 16 that cannot that has a claim of consent that cannot be used as a defense for prosecution. It also, and Representative Scott Holcomb has worked greatly on this, and I think we'll speak to it, the creation of the statewide sexual assault tracking system, which will ensure that the most prevalent and useful tool in prosecuting our state's sexual crimes when available is kept safe and tracked well. If there's any questions, I'll yield.
There are no questions.
Thank you.
The gentleman has yielded the well. The chair recognizes Representative Kennard to speak to the bill.
Thank you, Madam Chair. Today I rise in opposition to HB 720. To be clear, I support holding someone accountable for their wrongdoing and crimes of this nature. They are particularly harmful, and I believe we should also protect our larger society with effective security measures. As a director of a transitional reentry program that works with justice-involved men and women, we occasionally have someone in our program who is on the registry seeking rehabilitation. It is my professional opinion that there are already strong, sufficient, and appropriate safeguards to protect the community. Someone on the registry must check in with the local sheriff's office if there is a change of address. If they change jobs, they must also check in with the sheriff, and they must annually check in on their birthday. In addition, the registered individual cannot live within 1,000 feet of a school, daycare, church, or park. The registry is public record on a state-funded, highly accessible website. Any concerned citizen, any concerned parent can know who lives in proximity to them. To further penalize beyond these already stringent penalties with a residential warning sign and to impose a lifetime sentence of probation, I find unduly punitive and stigmatizing. Research proves that the offending individual who is further penalized and stigmatized will cease to respond positively to treatment because there's a sense of futility. HB 720, along with other legislation created this session, is an about-face to the criminal justice reform policies of the previous administration that have been working to make Georgia more just and more safe. Georgia already has more of its citizens on probation than any other state. We are 4 times the national average. Our very own Community Supervision Commissioner, Michael Nell, has told us that probation is not effective after 24 months. After that, it only serves as a trap to violate. It's also worth noting that probation administered by for-profit companies is a $30 million business in Georgia. To be clear, I support holding someone accountable for their wrongdoing, and crimes of this nature are particularly harmful. And I believe we should also protect our larger society with effective security measures. But I also believe that we want to offer a path forward for the guilty party and an opportunity for redemption. The Southern Center for Human Rights, Georgia Justice, they oppose these measures. Department of Community Supervision, they have a lot of concerns about the impact on their agency that is already buckling under an overwhelming caseload. In deference to time, I yield the will. Thank you, Madam Chair.
The gentleman has yielded the well. For what purpose does Representative Saines rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that under the reforms that were done under Governor Deal, there was a more lenient system of ensuring that we had the capacity to monitor dangerous sexual predators, and that this bill ensures that after 10 years of probation, those who have acted in good faith have a state-required review of their probation, and that judicial discretion is in place to allow for that probation, if applicable, be terminated?
As the gentleman states, the chair recognizes Representative Holcomb to speak to the bill.
Thank you, Madam Speaker. I want to talk about the second half of the bill. For about the last year, the Georgia Sexual Assault Response Team Project State Expert Committee has been meeting and thinking about other reforms that we can make to Georgia's sexual assault policies. That committee includes members from the Prosecuting Attorney's Council, the Council of Superior Court Judges, law enforcement agencies, statewide sexual assault nurse examiners, assistant district attorneys, and the Georgia Sexual Assault Kit Initiatives Project Coordinator. And if you turn to page 13 of the bill, that's where this section starts. It was previously House Bill 1076, but that has been in toto added into this legislation. The first thing that it does is, back in 2004, the General Assembly required each judicial circuit to establish a sexual assault protocol, to come up with policies and procedures for how sexual assault cases would be handled in each jurisdiction. What we have found is that many jurisdictions are not in compliance. So the first thing is in section 5-1 is to require compliance by having each judicial circuit inform the governor, lieutenant governor, speaker of the House, and chief justice of any non-compliant jurisdictions. We hope that that will force each jurisdiction to actually adopt and implement a protocol. The next thing that it does that's significant is that this bill will implement for the state of Georgia a tracking system for every sexual assault kit, meaning that when a victim reports to either a sexual assault crisis center or to a hospital and evidence is taken and put into a kit, it will then be tracked from that point all the way through to prosecution, which I think is something that we need, and it's something that we've been working on for a long time. And in lines 448 and 449, you'll see that it allows victims of sexual assault to anonymously track or receive updates regarding the status of their sexual assault kits. The next major part of the bill is that in coordination with the FBI, they have a program called the Violent Criminal Apprehension Program, VICAP for short, and it is the most violent serial murderers and serial sexual offenders. I've worked with the FBI to craft language so that way we would have data sharing from our law enforcement officials with the FBI to try to solve cases. So that VICAP part is also very significant and is in section 5-5. And then finally, the last part of the bill is with respect to sexual abuse of patients by doctors. It is very, very rare, but it does happen. And under this legislation, it would force the board, the medical board, to take action. Right now, they don't have to take action, and in the past, they would refer a doctor for counseling if a doctor sexually assaulted a patient. So this magnifies and increases, and I think improves, the response that we'll have on that issue, and it's supported by the Medical Association of Georgia and others. So I wanted to just walk you through those changes because I think that they are significant and worthy of favorable consideration. I'm happy to answer any questions on the sections that I discussed.
There are no questions.
Thank you.
The gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. There is a minority report. The chair recognizes Minority Leader Trammell to present the minority report.
Thank you, Madam Speaker. And I want to make clear from the outset that I completely support the section of the bill that Representative Holcomb just talked about and just described. But when we get to this portion of the session, when it's late, you get bills that are combined together. And so sometimes you have to make a choice between a bill that combines some really bad things with some good policy, like Representative Holcomb's policy that is incorporated in this bill. So my remarks are going to be very succinct on this. The heart of the issue that's the problem of this bill is lines 64 to 66. And that is that we are creating a life sentence for a whole new section of crimes. It's 2 strikes and you get a life sentence. And not all of those crimes that are enumerated below are equal in nature and magnitude. And this is a step backwards. I mean, if we decide that any of these crimes need to be sentenced in a more harsh manner, then we should deal with those crimes individually. But what we should not do is tack on at the end probation for life. Because probation may not sound bad. It's like, oh, it's just probation. But you are under the supervision and control of the state when you're on probation. And if you get a traffic ticket, or you go and you commit another offense that's a misdemeanor in nature, you can have the balance of your probation revoked. So this is a life sentence bill. And if you're for life sentences, you can be in support of the bill. But if you want to take a step back and carefully consider, I ask that you do that before you vote upon this bill. Madam Speaker, at this time, I would yield the balance of the time for the minority report from the gentleman from Sandy Springs, Representative McLaurin.
Chair recognizes Representative McLaurin for the remainder of the minority report time.
Thank you, Madam Chair. I'll start very quickly with a story. Around 2008 or 2009, you'll have to fact check me on this, I had a grad school project to come to the Georgia General Assembly from Athens and sit in on any committee of my choice and watch any bill of my choice and report back on what I saw. And I went to the Judiciary Non-Civil Committee, the committee that I sit on now. And I watched as we passed the super speeder law. Y'all remember, we added $200 to speeding fines, right? And after about 15 minutes of the sponsor's presentation, the question was, how did you pick $200 as the fine amount? Well, an aide walked up and whispered in the representative's ear, and after considering, the representative said, "A little bird just told me that that seemed like the fair and just amount." And then a judge spoke for about 10 minutes and tried to fit as much words into a speech as I normally do when I get up here, and she goes, "You don't understand. This isn't going to change behavior. People are going to keep speeding. They're going to get caught. They're not going to be able to pay the fine. They're going to get trapped in the system." And the committee said, "Well, if you can't afford to speed, then why do you speed?" She said, "What do you think I tell the people who come into my courtroom?" Well, I got on the elevator with her on the way down, and she's just shaking her head talking to somebody. She said, "I did my best. I tried to tell them what would happen, but it didn't work." Now, I don't have any data for you on super speeder, but what I do know is this. We have a legacy of criminal justice reform in this state that I am proud of. As a Georgian, as a current member, the Deal criminal justice reforms are one of, to me, the bright lights of governance in our state. And my commitment when I came and ran for office was, that was one of my #1 priorities. I asked the Speaker to be placed on Judiciary Non-Civil. He was gracious enough to put me there, because that's the work that we need to be doing. But it's hard work, and one of the reasons it's hard work is because sometimes the people that you're advocating for, that you're talking about, are not the most popular people. I think that's the hardest part about our jobs, is that when we're put to the test to ask the hard questions about what should happen to people who nobody is publicly going to stick up for. And in this case, you know the play Les Miserables, Jean Valjean, right? Reject of society, nobody wants to worry about what's going on with him because he committed a crime. So he's on the outside of what we consider to be the in-group in society. That's these folks. These folks are the ones who have committed in some cases, pretty heinous crimes. But like the leader just said to you, not every crime is created equal. And we can't just do something because it sounds right, because the narrative's simplistic. Well, they did a really bad thing, so lock them up for life and just throw them away. That can't be our attitude. Our job is the hard one. We have to be sensitive to what the crime deserves. Proportionality. Does the punishment fit the crime? And the story of this bill is that we were putting lifetime ankle monitors on people who committed some of these crimes, but the Supreme Court ruled that it violates the Fourth Amendment to the Constitution to put a lifetime ankle monitor on somebody if they're not subject to a valid sentence. So what did we do in our wisdom? Instead of saying, well, maybe we should rethink whether ankle monitoring is the best way to achieve our ends, you heard the gentleman, Representative Kennard, speak to other ways that we restrict the lives of people committed to these crimes. Instead of doing that, you know what we did? We flipped it the other way. We said, well, why don't we just make every sentence a life sentence? Then we won't have that Fourth Amendment problem. We can put an ankle monitor on anybody. That's what this bill does. That's the legacy that we're going to be moving in the direction of, not the Deal criminal justice reform legacy, which is less restriction, more thoughtful, proportional, evidence-based approaches. Instead, we just put just a list of crimes that now they get a life sentence because we had a logistical constitutional problem, just a small constitutional problem with the way we wanted to do business. That's the cart before the horse. I don't know how many metaphors for backwards I could use, but it's all of them. What we're asking you to do today is to think about proportionality. We're asking you to think about the way that this process should be done. And I have the greatest respect for the chairman of the Judiciary and Non-Civil Committee, but I do not want to do policy where we say the result is going to be this, and we're going to get there no matter what, even if it violates our sensibilities. I'll tell you one last thing about this that I think is telling about how this bill is put together. We said over and over again in committee, if you're going to extend the maximum sentence for these crimes, you got to go into each code section, every single one of them. You've got to open them up where they have maximum sentences. Some of these have maximum sentences, 10 years, 20 years, whatever. You've got to go into every single one of those code sections and say, the maximum sentence is not 10 years, it's life for every single one of those sentences. You know what we did? None of that. We didn't go into each individual, and there may actually be a logistical problem where courts don't even accept this because they say, you didn't change the maximum sentences, so this life probation language doesn't mean anything because you didn't go in and open up every maximum to make it life. And I think the reason we didn't do that is because we don't want to admit that that's the way we're trying to solve this problem. We don't want to be on record making every single one of these crimes a life sentence because it looks bad. And if your probation gets revoked, guess what? That's life in prison. 30 years before you get to apply for parole if the balance of your probation gets revoked. I just want us to think about what we're doing today. There's going to be a lot of green on that board, but it's not going to be up there without us at least having an opportunity to make us think about it. Thank you very much. I yield the well.
The gentleman has yielded the well. For what purpose does Representative Saines rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that I've twice heard a metaphor of a traffic ticket for offenses that are listed within this bill, including aggravated assault, kidnapping, trafficking an individual for sexual servitude, rape, aggravated sodomy, statutory rape, child molestation, aggravated child molestation, enticing a child for indecent purposes, all listed within the bill, and that this bill also provides what is already utilized as a split sentence to include the ability to put a life probation on the new environment we're created with after the Park v. State decision.
Is that not true? If the gentleman so states, the chair recognizes Chairman Estration to present during the chairman's time.
Well, thank you, Madam Speaker. Ladies and gentlemen of the House, I know that we have many bills on the calendar today, so I'll just jump right to the point here. A no vote on House Bill 720 will endanger the public in Georgia, will endanger our children, will endanger the citizens of the state. And a lot's been set up here, which I'm afraid are unfortunately mischaracterizations of what brought this bill about and what this bill does. So let me attempt to correct the record here so that you can understand what's actually before you. In 2019, while we were in session, the Park versus the State case, an opinion in Georgia Supreme Court was rendered, which said that sex offenders could no longer be held under certain sex offender conditions if it was beyond the term of their sentence. And as a result, overnight, ankle monitors were cut off across the state of Georgia on sex offenders immediately when that opinion happened. And Georgians and law enforcement looked to us here at the state capitol to address the issue. What do you do when the law only provides for a certain period of time for supervision, but you are dealing with a dangerous individual who poses a risk to the citizens of this state if they are not under certain supervisory conditions? So we got to work immediately on it. And Representative Saines, as a freshman legislator, took on this very difficult issue and introduced House Bill 720. Now, we didn't rush a bill through. It was late in session. We didn't rush a bill through. We studied it throughout the year and came back this session, and Representative Saines did a great deal of work to refine the policy and bring to you much of what's before you here today. And that is this: in order for probation for life to be available, you must have committed your second, what I would submit to you is an inherently dangerous felony. Okay, not within the legal statute, but there's a list of dangerous sexual felonies. For after a second conviction, the court would give probation for life, not a life sentence in prison, as has been said from this well here today. That's incorrect. That's not what the bill says. And on top of it, as Representative Saines identified a moment ago, there is language in the bill which requires judicial review when a sentence is given under those circumstances at the 10-year point, and then every 5 years thereafter, to make sure that a continuation on probation is appropriate. Now, did a little birdie give us 10 years? No. The Sex Offender Review Board, SORB, testified in the committee in which I chair that that is the appropriate length of time in order to determine whether or not a person will be a danger to the public going forward. 10 years is a minimum that's necessary in order to make that determination. All right? I served on the Council on Criminal Justice Reform for over 3 years. All right? The cornerstone of criminal justice reform in this state was public safety. That's how I was able to come before you on so many bills, as you recall, in that area, and promote good policy that was smart on crime in our state, that really went after the underlying causes of criminal offenses, not just simply having heightened sentences and throwing people in prison and saying, we won't think about that. It was the exact opposite of that. It was, let's be smart about how we address criminal justice in our state. It's the morally right thing to do. Oh, and by the way, it saves the taxpayers money. This bill is completely consistent with criminal justice reform. Because what are we doing? We are saying that for the most serious offenders where public safety is in jeopardy, we are going to allow oversight to ensure that the public is protected. But we are not going to have these excessive sentences or respectfully these other matters that Representative Kennard tried to bring up to confuse this issue. That's not what this is about. What this is about is protecting the public and there being supervision to see that through. Now, the Sex Offender Review Board also testified in committee that they need additional information in order to make their reviews and make their assessments, to make the best possible recommendation to judges and for ultimate parole conditions and things like that. And that's also included in this bill. I haven't heard anybody speak about that today, but that's a critically important component. Don't we want the Sex Offender Review Board to have as much information as possible so they can determine what tier of threat level the sex offender is? When we have comprehensive legislation in important areas like that, it can be real easy to sit back and say, oh, I see life sentence written in here somewhere. I'm just going to reject it. I'm going to reject it and go campaign and say how I truly believe in criminal justice reform. But when we're governing and making decisions about what is actually in the best interest of Georgians in this state, what's going to keep them safe, what's going to keep their children safe, we have a responsibility to truly call the bill what it is. And that is a measured approach to ensure public safety, to give judicial discretion where it's needed, and to allow for adequate supervision of offenders who need it. I'll also just commend Representative Holcomb here for his outstanding work. We have had a very busy session, and his legislation is included in this bill because it is so important, his bipartisan measure to allow for sexual assault kits to be tracked in the state of Georgia, for doctors who are known to have committed sexual assaults on their patients to not be able to hold medical licenses in our state. All of this is included in this measure, and any member that puts up a red vote on this bill is voting against all of those important measures. There's no two ways about it. A yes vote is a strong message that we care about ensuring that law enforcement, the courts, Sexual Assault Board, and many other agencies do what needs to be done to protect Georgians. A red vote is a rejection of the underlying public safety concerns that brought this bill about. And I'll leave the choice to you. Thank you, Madam Speaker.
The gentleman has yielded the well. For what purpose does Representative Clark rise? She waves. For what purpose does Representative Park rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that Georgia is the #1 state for having the most people on probation and spend about $40 million a year on private probation?
As the gentleman so states. For what purpose does Chairman Petrie rise?
Parliamentary inquiry.
State your inquiry.
Madam Speaker, is it not true that according to the Bureau of Justice Statistics, in a study that was done in 2005, released sex offenders made up only 5% of the population released from prison in this country, yet accounted for 16% of the arrests for sexual assault or rape in the 9 years following? Is that not true?
As the gentleman so states. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. And the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machine. On the passage of the bill, the yeas were 98, the nays were 63. The bill, having received the requisite constitutional majority, is therefore passed.